variations from print to print in this edition.
Doesn't matter. I'll take this one.
Would you like it framed in the usual way?
I'd like it in a brushed metal frame.
You have activated the emergency two-way communication channel. You have activated the emergency two-way communication channel. Air Unit 43, Air Unit 43. Coordinates 24 1B Quadrant 2. Coordinates 24 1B Quadrant 2. An apparent 743. An apparent 743.
I think they're moving down the hill. There's a shopping center just below the house.
You. This is the police. Remain where you are.
I'd like all available surface units into this area.
What is this? What's going
Hands
on?
above your head. Spread your feet. Further.
I found that. Back by the corner, a man ran by and dropped it. I picked it up off the sidewalk. I didn't want to leave it laying there. And what's the matter? What's going on? You scared me to death.
Please come with us.
This is a new machine. But undoubtedly you have heard of it since it's received a great deal of publicity over the years of its development. The subject is seated here. And beams of intense radio emissions are directed into his cranium. The radiation is precisely controllable in width and direction to the millionth of an inch. The paths of energy act much like electronic probes inserted beneath this skull. They stimulate in a highly selective fashion portions of the brain. In this way, absolute recall is painlessly and harmlessly induced, and all resistance to discussing what is remembered broken down. In short, this is a completely reliable truth machine. Now, in accordance with the new state law, suspects must submit to interrogation while linked to the machine.
It would be best, of course, if this was done voluntarily.
No.
I would ask that you consider this request carefully.
No.
In that event, the state will be forced to get a court order to compel you to submit to an interrogation while linked to this machine.
Am I allowed to get an attorney?
Of course.
The Fifth Amendment to the Constitution of the United States says, "No person shall be compelled to be a witness against himself in a criminal case." But what happens to this privilege against self-incrimination and other constitutional guarantees under the impact of advanced technologies? And what balances can be struck between the rights of the individual and the rights of the state when the state has available to it completely reliable and impersonal means of law enforcement?
The prosecution is seeking a court order that will allow them to question the suspect while he is linked to the Snyder machine, or what is more commonly known as the truth machine. According to the new state law, the prosecution must show that it has probable cause. That is, good reason to believe that the suspect has committed a specific crime. And the questioning, while the Snyder machine is in use, must be strictly limited to matters directly concerning that crime. Everything seems to be in order here. There seems to be probable cause, and the state is willing to limit the scope of its interrogation. The only question, then, seems to be the constitutionality of the new law. The defense attorney claims that it violates the Fifth Amendment to the Constitution, which states that no person will be compelled to be a witness against himself in a criminal case. Since this is the first constitutional test of the new law, this hearing is of great importance. Will the prosecution please open the proceedings?
Your Honor, these proceedings were called to test the constitutionality of a new solution to an ancient social conflict, the conflict between the rights of society and the rights of the individual. In the past, courts, you, Your Honor, and your predecessors, have had the difficult task of both protecting society against thieves and murderers and ensuring that no citizen was falsely accused of being a thief or a murderer. Nowhere has this problem been more acute than in the area of personal confessions. But those men who wrote our Constitution and those judges who have interpreted it have decided that they would not allow a man to have his testimony compelled before a court of law, even though often only his testimony could answer the question of guilt or innocence. The reason for this restraint has been obvious and important. If such testimony involuntarily given were allowed in a court, the police would have a powerful incentive for using various forms of coercion to extract a confession. Now Dr. Snyder has perfected a machine and eliminates the contradiction between the rights of society and the individual. This machine, infallibly and painlessly, can establish who is telling the truth. I'm sure you know, Your Honor, and the defense counsel, I'm sure, is aware, that the infallibility of this machine is not at issue. Various internationally recognized panels of jurists, psychologists, engineers, lawyers, doctors have all testified to the absolute reliability of Dr. Snyder's machine. What is at issue is whether the machine should be used in this case. And that raises the question of whether the police have good grounds for arresting this man. This man was found near the scene of a crime. He was found there shortly after the crime was committed. He was dressed in clothes similar to those worn by a person seen by a police officer on the two-way emergency home video system that the woman activated shortly before she was murdered. When he was challenged by the police, he fled. When he was caught by the police and searched, they found on him a piece of jewelry taken from the victim's home. All of these facts constitute, in my opinion, Your Honor, and I'm sure in yours, ample grounds for bringing this man before you, ample grounds for detaining him, and ample grounds for you to issue an order now authorizing the police to use the machine to determine this man's guilt or innocence. Thank you.
Attorney for the defense.
We have listened to the detached, technical, and cool arguments of the prosecution, and it seemed as though technology itself were speaking. It's time now to represent the view of humanity. A great legal scholar once wrote, "The Fifth Amendment is the great monument in man's struggle to make himself civilized. We here today are again engaged in that struggle. The Fifth Amendment provides that no person shall be compelled in a criminal case to be a witness against himself. It helps to protect both guilty and innocent alike. It outlaws any physical, legal, moral compulsion utilized to make a man convict himself. The aversion to compulsion, which culminated in the Fifth Amendment, has deep roots in Anglo-American history. A landmark case arose in 1637 when John Loudburn was charged with heresy and sedition by the Star Chamber. In that day, Your Honor, a man could be guilty of treason for merely having disloyal thoughts. For example, imagining the death of the sovereign. The Star Chamber ordered Loudburn to take an oath wherein he was to answer all questions about the sovereign. He refused, claiming it was an invasion of his dignity. "I will never take it," he shouted. The Star Chamber angrily put him in the Tower of London. But the House of Commons soon released him, saying that such a procedure violated a basic liberty, thus establishing the privilege against self-incrimination. In the 20th century, the Congress of the United States ordered citizens to take similar oaths and threatened punishment there also, and the Supreme Court of the United States intervened with the shield of the Fifth Amendment, declaring that not even Congress can compel a man to incriminate himself. Supreme Court Justice Frankfurter reminds us that we have an accusatorial, not an inquisitional system. The state must prove its case by independent evidence freely secured and not by extorting words from the lips of the accused. We should also not lose sight of another rationale for the Fifth Amendment, the fear of perfect law enforcement. Society's laws are not perfect. They were drafted by fallible men, not by infallible machines. They tend to reflect the bias of the period. How ridiculous it appears to us that at one time men were executed for thought crimes. That was a form of treason to imagine the death of the king. It is against such extravagances and abuses that the Fifth Amendment protects us. More is involved today than the rights of the accused. The very quality of civilized life itself is an issue. For the Snyder machine is but one more device in the state's electronic juggernaut, crushing our human dignity. The state has developed electronic beams to penetrate walls and spy on us in our homes. It has developed electronic eyes to scan our streets and our stores to spy on us. It has electronic dossiers which computerize and record and memorize every detail of our personal lives. And now the state seeks to peer inside the core of human personality, inside the sanctuary of the soul itself. Whatever security is gained by this, Your Honor, is not worth the price in human dignity. And who's to say that once inside the mind, the state will not inspect our political thoughts, sexual indiscretions, emotional problems, and every illegality we have ever committed? And what guarantee do we have that this horrendous machine is not going to be used for tyranny? That it will not be directed against critics of the state? Who will dare criticize the state when it has such an enormously powerful weapon? We want to progress through technology, but we do not want technology to consume us. I urge Your Honor to reject the forced use of this machine as unconstitutional. Thank you.
Thank you, Counselor. Does the prosecution wish to mount a rebuttal of defense remarks?
If it may, Your Honor, the cool voice of technology would like to respond to the voice of humanity, because what I hear from the defense counsel is not a defense of humanity. He is defending, in essence, the status quo, what we now have for law enforcement, characterized by rising crime rates, by police who find themselves handcuffed in the performance of their duties, and by judges, such as yourself, Your Honor, who find it impossible to strike that proper balance between the rights of the many and the rights of the few. Now, the defense counsel has mentioned 4 arguments in defense of his position. Our fear of compulsion, our fear that the state may inquire into our political and personal views, our fear of perfect law enforcement, and lastly, that we are living in an age characterized by electronic surveillance. Let me take up these arguments one at a time. First of all, the argument of compulsion. Surely we all dislike compulsion, but an organized society depends in some important measure on compulsion. Compulsion, indeed, to ensure our own freedoms. We are compelled when we pay taxes to support the state. We are compelled when we are required to come here, to this courtroom. We are compelled when we are required to obey laws. The issue is not compulsion, but whether the compulsion is just or unjust. Let us come now to the question of personal and political inquiry. I realize, the defense counsel realizes, that there was time in our history in which congressional committees, in which judges and police officers and star chamber groups looked into the political loyalty of various persons and attempted to inquire into matters that were of no concern to the state. But what is at issue here is not whether this man has imagined the death or murder of the king. The issue here is whether this man has actually murdered a woman. Murder is not a crime about which reasonable men can disagree. It is not a state of mind. It is not a political opinion. Murder is always wrong. And we are only asking you to authorize the use of the machine in this case today, a case of murder. Then we come to the problem of what the defense counsel calls perfect law enforcement. Now, we are not proposing perfect law enforcement. We're not proposing dredging memories of old crimes out of the memory of all of us. We are simply proposing that in the case where we have a crime, and a serious one, and a suspect, and a real one, that we should be given the power to determine once and for all, without cost or suffering to him, whether or not he's guilty or innocent. With respect to this question of surveillance, I would have to agree with the defense counsel that the vision of a state operating a large computer that is inquiring into our mind at all times is a depressing prospect. But again, that is not what is at issue here. We are not proposing to use a machine here that sends electronic beams through concrete walls. We are not proposing that the Schneider machine be shrunk to the size of an olive and placed in a martini glass. We are not proposing that people's thoughts and feelings and reactions be kept under continuous electronic surveillance. We are proposing only that a perfect lie detector be used in the specific and limited case of this man and the crime of which he is charged. And we are proposing to do it only with your consent, Your Honor. In addition to these matters, however, there's a larger issue that perhaps the defense counsel did not allude to as fully as he might. The larger issue, as I see it, is the question of the rights of society. For generations, we have willingly reduced the rights of society in order to ensure, or rather more accurately, to minimize the chance of any innocent man being sent to jail. We've accepted great risks to our life, our property, and our well-being for that end. We've done it because there was no way in the past we could ensure that only the guilty would be punished and only the innocent would be set free. Now we have that opportunity. Now we have an opportunity to increase the rights of society at no loss to the rights of the individual. And for these reasons, Your Honor, I urge you to waive these constitutional objections, to admit that circumstances have changed, to note that the Constitution is a growing document that adapts itself to new realities, and to recognize this new reality, and to authorize the police to use the Schneider machine to find out whether this man has committed this crime. Thank you.
Thank you, Counselor. The issue we're dealing with today is not unlike the problems we've been dealing with over the years, involving interrogation in police stations and by congressional committees, except that Now the state has a new and powerful weapon, the Snyder truth machine. If the Fifth Amendment privilege against self-incrimination is simply to protect the innocent, then it has no bearing here. For the Snyder machine is completely reliable and does not convict the innocent. But if the Fifth Amendment is devised to protect the individual against the all-powerful state in which all laws are perfectly enforced, then the privilege against self-incrimination is applicable here, and the Fifth Amendment may rightly be invoked. The crime that was committed was savage, and society has the right to use all modern tools of law enforcement to apprehend the criminal. On the other hand, it is as important as ever that a man's privacy be respected and that his thinking not be controlled by the state.
The privilege against self-incrimination and the impact of advanced technologies on constitutional rights can introduce complex problems. Should this man be forced to submit to questioning while linked to the Snyder machine, or would this be a violation by the state of his constitutional rights?
The case is complex. I will inform you of my decision shortly. Thank you.
How would you decide this case?